Technology Consulting, Ernst& Young LLP. Thank you, Mr. Kalra, for sparing some of your valuable time to come over to Kolkata, especially to share your valuable insights with our members. We take this opportunity to acknowledge the support of our very own Shri Harish Agarwal, ENY, for putting this together. Since he is traveling abroad, he could not personally attend this program, but he has sent his best wishes. In 2006, mathematician Clive Humby famously said, "Data is the new oil." While that phrase captured the value of data in the digital age, today we realize that the analogy goes deeper. Unlike oil, data is not merely a resource. It is the reflection of people's lives, behaviors, preferences, and identities. This makes its protection not just an economic necessity, but a moral and legal responsibility. The DPDP Act 2023 governs digital personal data in India, whether collected online or offline and later digitized. It also extends beyond India's borders when such data processing relates to offering goods or services within the country. We must also recognize the journey that led us here. The earlier Personal Data Protection Bill 2019 was withdrawn and amid concerns relating to issues such as data localization, regulatory scope, and broader policy implications. While the current framework is more streamlined, certain questions remain, particularly around the extent of government access to data and the need to maintain transparency and accountability. In fact, this issue is currently under consideration. On 13th April 2026, the Honorable Supreme Court, while hearing a PIL on DPDP Act 2023, sought the Centre's response on concerns relating to transparency and its interplay with the Right to Information Act 2005. This highlights that the law is still evolving and its interpretation will continue to develop. Equally important is the question of ownership and control of personal data. For businesses and employees alike, it raises a fundamental issue: who ultimately has authority over personal information? The rules make it clear that while organizations may process data, control rests with the individuals, requiring companies to treat personal data not as an asset to own, but as a responsibility to manage with accountability and respect for individual rights. The Digital Personal Data Protection Rules 2025 mark a decisive shift from broad principles to enforceable compliance obligations. The real challenge, ladies and gentlemen, for businesses today is not understanding privacy in theory, but implementing it effectively in practice. At the heart of the framework of the rules is a strong consent architecture. The rules emphasize clear, informed, and unambiguous consent, requiring organizations to move away from fine print toward transparent user communication. At the same time, the concept of deemed consent, now refined under certain legitimate uses, introduces a nuanced balance between operational necessity and individual rights, while also recognizing certain legitimate uses. Further, the new rules mandate strict data retention norms and impose prompt breach notification obligations, making strong cybersecurity and response systems essential. The framework also introduces enhanced responsibilities for significant data fiduciaries, including audits and impact assessments, and extends accountability to third-party vendors. I am sure Mr. Kalra will share his expertise on these critical issues in his presentation. KYC requirements make organizations in the field of finance, including professionals like us in capital markets, handle customer data maintained digitally. Protecting data becomes our fiduciary responsibility and not just compliance. For us investment bankers, data is central to risk management, valuation, and investor confidence. Robust data protection frameworks directly influence due diligence as data governance, breach history, and regulatory exposure are now key factors in assessing a company's risk profile and long-term sustainability. At the same time, friends, the framework has several positive aspects. It strengthens protections for children through stricter age verification mechanisms and places clear obligations on organizations to act swiftly in the event of data breaches. The provision for significant penalties underscores the seriousness of compliance and the need for robust systems. On cross-border data transfers, the rules allow transfers to notify countries, signaling a shift from strict localization to a more flexible, trusted geography-based approach. I request Mr. Kalra to provide his views on these aspects of the rules as well. And ultimately, the challenge before us is clear. How do we keep pace with these rapidly evolving requirements while safeguarding sensitive information and maintaining the highest standards of ethical conduct? I am confident that Mr. Kalra's presentation, this complex subject, will become far more accessible to all of us, perhaps even transforming our knowledge series into Made Easy series. With these words, I request Mr. Kalra to kindly address the gathering. Thank you, ladies and gentlemen.
Thank you, Mr. President, and good afternoon, everyone present here. It was a remarkable introduction to the topic that you've done. I'm sure this is the best introduction that I've heard in so many presentations that I have done. Thank you for that. Can we have the slides? Thank you. So before we go into the details, and I have the clicker here, I can change. Let me, if there are any questions, we can take those in between also, or if towards the end, we can keep 15-20 minutes. I'll try and finish in towards the end for 15 minutes. And before I start, let me start with asking the group here a particular question. What comes to your mind when you hear DPDPA? Is it the first time you're hearing? You've heard it before? What does it mean? So he's given a beautiful introduction. I'm sure everybody now here understands what DPDPA to a large extent is, but what does it mean for you as an individual?
It's basically data privacy and data protection for individuals like all of us who keep, say, for example, the bank accounts have a lot of details which are private details. So from now onwards, I mean, when the law becomes enacted, like after DPDPA 23, now the rules 25 has come. So I believe by 27 May, this needs to be implemented. So by that time, as Mr. Pasrija has mentioned about the consent management, that is at the core of the whole thing, which means the consent needs to be taken from each and every individual, and for the consent for a period of time. So it can be deleted at a point of time when the individual wants it to be deleted, and so on and so forth. So basically, it's data privacy and data protection.
Perfect. Thank you. Yes.
It's a biometric data. If we talk about hospitals, it's a medical data. If we go to a shop, it's a phone number and other details that they collect. So all these are part of a personal data which can influence an advertiser to target us.
Perfect.
The recent case.
Yeah, please go ahead.
So sorry. So the recent case with respect to WhatsApp and Meta, that is something which is very much interesting. We all have these apps in our mobile phones, and that also have something concerned with relation to privacy and our personal data, what we are going through, what we are watching, what we are doing, the digital footprints. So I hope that this session will definitely clarify most of those questions which are currently in debate.
Okay.
Last observation.
My basic premise is the data that we are giving for a specific purpose, that should be utilized only for that specific purpose, and it shouldn't really be, as Mr. Pachicia said, it shouldn't really be the property of that individual or that corporate, and shouldn't really be marketed for any other purpose without my consent.
Very good. So the Calcutta is holding up the reputation of intelligent peoples. Thank you. So that is what actually DPDPA is. So what I'm going to cover in the next 1 hour 45 minutes is essentially a refresher on what the Act is. What does it mean for companies? What does it mean for businesses, small businesses? And what does a organization needs to do to stay compliant? And what are some of these immediate short-term, medium-term, and long-term actions that they can take to ensure compliance? So that is what we would be covering in the next 1.5 hour, 45 minutes. The so like Mr. Pachicia mentioned, the Act, the first version of the Act came in 2019, but the journey actually started much before that. The journey started specifically for India, started in 2017, when privacy was declared as a fundamental right under the Puttaswamy judgment. There were the other laws in the world that existed much before that. In fact, the first, and you would be surprised, the first data privacy law in the world was in 1978 in France. So, and then they had their respective journeys from 1978 to EU GDPR, which came in 2018. For us, the IT Act was there in 2000, but it did not specifically focus on privacy. Privacy came to the front line in 2017 when it got declared as part of the Puttaswamy judgment in 2017. In 2018, Justice Sri Krishna Committee came out with a report which was about 95% aligned with EU GDPR. So EU GDPR is a data protection law which is followed by Europe. It's European Union General Data Protection Regulation. The July 2018 version was pretty much aligned with that. So it did not serve the Indian context. This was then later submitted for a parliamentary committee. A JP Joint Parliamentary Committee was formed, which went through the Personal Data Protection Bill of 2019, and that's what Mr. Pachisi also mentioned. Then JPC released different versions. There were, I would say, the Act has gone through multiple ups and downs. It has seen its own tipsy-turvy curves. They started with including non-personal data, then personal data. So it has its own share of curves that the law went through. In August 2023, the DPDP Act got approved. In 9 days from the time it was shared to it was getting it signed by the President on 11th August, that was when the Act was actually notified. Before its notification, it went through its fair share of consultations that the MeitY did across different industry bodies in public consultations which were done. From the August 2023 to November 2025 is when the rules came out in November 2025 on 13 November. The rules have actually complemented and given more details into how an organization can go about comprehending and implementing the Act. So that's what the rules have intended to do. So that has been the journey for the Digital Personal Data Protection Act that we have in India. So the first version that we had in 2018, it was about 200 odd pages. The current version that we have is a 21 pages Act. It is one of the shortest acts which we have globally, and to be it is the first act globally wherein the data principle has been mentioned as a she. Every law across the globe that you pick up, the subject has always been mentioned as a he. Keeping in line with the women empowerment of the government, the government used the word she in place of a data principle. And when we cover the subsequent slide, I'll talk about the difference between a data subject and a data principle. That was the case. So that's where we are today. There are different timelines that the government has given for companies to implement the Act. But before we get to the what the timelines are, the first is applicability. To whom is the act applicable? That is important to understand for any organization, what is applicable to me and what is not applicable to me. So from an applicability perspective, as the name says, the act is applicable on digital personal data. So the data which is collected or processed in digital form, or data which is collected in hard copy but later digitized, it is applicable on that data only. The data which stays in non-digital form does not come under the purview of the act. So which means the visitor registers that we have when we enter a particular office, if that data stays in that visitor register, it does not come under the purview of the act. But the moment that register is scanned and entered into a system, the DPDP Act would apply on that form of data. That is first. Second is, it is applicable only to personal data. It is not applicable to business data. So business confidential information would continue to be governed by various other regulations that the country has. Only personal data would get covered by the DPDPA. Now the question which comes is, what is personal data, right? So gentleman here gave some examples of name, mobile number. The definition of personal data is very broad under the Act. The personal data definition says any information which can help you to uniquely identify an individual, whether directly or indirectly, shall be considered personal data. Now, because the definition is so broad, it leaves room for error. At the same time, it gives flexibility to the organization to define what is personal data for them and in what process. So I'll give an example. So if I were to go on LinkedIn and search Lalit, I will get hundreds of records. I add Lalit Kalra, maybe the number of people, entries that I will get will reduce. I enter Lalit Kalra EY. The likelihood of getting more than 2 or 3 people is minimal. So the search result will give me 2 or 3, right? If I add one couple of other parameters, I will be able to narrow down, okay, this is the Lalit that I was looking for. So if you see, we have different elements here. We have name, we have surname, we have organization name. All 3 individually did not help me to identify a person, but all 3 combined have helped me to identify a person on one platform. The same logic is applicable in my database also, in the data that I collect. If only one particular data element can help me identify, so for example, let's say a mobile number or a passport number or a Aadhaar number, which can help me to uniquely identify an individual, that's personal data and PII. PII is personally identifiable information, which will help me to identify that individual. Another example here is, so we have a laptop ID here. The laptop ID, every organization today will have laptops. If I give the laptop ID to a HR function, would they be able to get me anything? No. Finance? No. But if I give the laptop ID to the IT guy, he'll give me the kundli. Right? So that's the difference. A laptop ID is personal data when it comes in the IT process, but it is not when it is in the HR process. So that is what the difference is, and that is where the organizations need to be cognizant of when defining what is personal data for them in what process. So that is the applicability of the law. The law, there are certain exemptions also to the Act. The law does not apply to data which is shared for domestic or personal use, which means data shared among friends, data shared voluntarily by one individual to the other. But that does not mean that individual who is collected data, so for example, let's say we exchanged card today, that does not come under the purview of DPDPA. But tomorrow I go to many such conferences. Tomorrow I want to start my own company and I want to utilize the information that I have collected over the years. That's when the DPDP Act would start to apply, because now the information is no longer being used for domestic or personal use. It is used for commercial use. So that is the difference when it comes to domestic or personal purposes versus commercial. The other thing where it does not apply is where I as an individual go and make the data public. So I go on LinkedIn and share my email ID and everything. That's when the law does not apply. Having said that, that does not mean that companies can scrape the internet and use my information. While they may be able to collect that information, for that organization to be able to use that data, they would have to ensure compliance to DPDPA. Okay, the law is applicable to companies which are established in India or present in the territory of India. It is also applicable to companies which are outside of India but collecting and processing data in the territory of India. So to all those companies also it is applicable. So it has extraterritorial applicability as well. So WhatsApp, Meta, all of those companies would have to comply with the act. Now, as we move forward, so the law has 44 sections, which is divided into 9 chapters and 23 rules. The reason we are saying, I'm specifically saying this is, there are 3 main words on which the entire act is actually based on. In chapter 2, it talks about obligations of data fiduciary and rights and duties of data principal. The entire act is based on these 3 pillars and 3 words. There are obligations on an organizations and there are rights and duties of an individual. There is nothing apart from these 3 words which actually takes care of DPDP when it comes to an organization. So that's why we thought we'll have these brief because the lawyers want to understand how many sections, how many rules and so on and so forth. Therefore, we thought, but these 3 words are important: obligations of organizations and rights and duties of data principal. As we go forward, we'll be covering these 2 aspects. So there are some key parties that we have. The first key party that we have is the Data Protection Board of India, which is also called as DPB or DPBI. It is a board established by the central government to monitor the compliance of DPDPA within the territory of India. It is the regulatory body which will be ensuring that DPDPA is implemented by organization and enforced. They will also be responsible for sharing and releasing guidelines, investigating any incidents that happen, penalizing the organization. So that would be the nodal body for ensuring DPDPA implementation within India. The next term, which is data fiduciary, is an important term, and I will try and if required, I'll try and share mapping with the EU GDPR if anybody is interested in. A data fiduciary is the entity or the person who either alone or in conjunction with other determine the purpose and means of collecting and processing personal data. What it means is, as an entity, I define what data do I need, why do I need, and how will I collect it. What, why, how. If as an organization, if I am determining these 3 for the personal data, I am a data fiduciary. If I am not determining the what, why, how, I am just working on behalf of somebody, I will be a data processor. Based on the contractual agreement that I will have, I will be a data processor. The reason this is important is to identify what is your role. Because under the Act, there are no obligations on a data processor. A data processor is free to roam around under the Act. Therefore, it is important to understand where the organization will be acting as a fiduciary, where will it be acting as a data processor. Any entity which is defining the purpose and means of collecting the processing personal data is data fiduciary. What does it mean when we say defining the purpose and means? Let's take a bank, for example. A bank today wants to have its sell a new credit card and wants to do a survey. They hire a entity that for market research. As part of that market research, they say we want to understand how is my credit card doing and how are people perceiving it. That is the agreement purpose that they've given. They've given it to the marketing agency. They've not defined anything else. It is up to the marketing agency to determine what data they will collect, how they will collect, why would they collect, right? Vis-a-vis. So in this case, the marketing agency also becomes a fiduciary because they are defining what, why, and how. The other case is a bank goes to a marketing agencies. They want to do the same survey, but in this case, they tell them on what would be the system for survey, for what is the age criteria, for how long will the data be retained, why would they be doing it, so on and so forth. The marketing agency is merely doing what the fiduciary is asking. So that is where they act as a processor. This will be important in case of dealer management systems, distributor management system that a lot of organizations will have, based on what is the role that the fiduciary is playing and what is somebody doing on their behalf. So all your IT vendors working on your behalf will be data processor. Similarly, any other vendors that you have will be classified as data processors. Now, unlike other laws which have given a term of data controller for a data fiduciary, the Act has kept the Indian context in mind. Globally, all the companies are treated similar. Whether it is a smaller company or a larger company, if you meet the applicability criteria, you have the same number of control that you have to implement. In the Indian context, this is a little different. How it is different is, they've divided the companies into two parts, data fiduciary and significant data fiduciary. A significant data fiduciary is a subset of data fiduciary, meaning it will be a class of data fiduciary which would be given by the government based on volume of data, based on the risk to the data principal, based on the harm that the data may cause to the individual. Therefore, segregating the companies which have large volume of data vis-a-vis smaller volume of data companies, or based on the digitization that the companies may have achieved, so that the compliance does not become a burden for everybody. There are additional obligations on a significant data fiduciary which make it a little more difficult and more controlled environment vis-a-vis a normal fiduciary who has to comply with some certain minimum mandatory guidelines. So that is how the differentiation is. So when the consultations were happening, they did with the industry bodies. I also attended one of the consultations with the Honorable Minister. So there we asked him a question, why are we complicating? Why not follow the other laws of the world and keep it simple? So that's where the thought process of the government became clear. They wanted to at the Indian context and not have a compliance burden for every small organization. We talked about EU GDPR, and they had some different views in terms of how it has impacted innovation across the world. So they wanted innovation to survive and sustain and do better, and therefore this classification. So companies which have large data should implement more controls vis-a-vis companies who have lesser amount of data, common logical sense. So that was the thought process, that a conglomerate which has huge volume of data should be doing more vis-a-vis a smaller company, manufacturing company doing B2B businesses, who does not need that kind of control, has data but not that amount of data or digitization to put them under the compliance burden. So that's why the segregation between data fiduciary and significant data fiduciary. This does not exist anywhere across any of the other laws of the world. So, data processor we've covered. Any organization which is working on the instructions of data fiduciary to process personal data. There also similar logic. Globally, both a data controller or a data fiduciary and a data processor have equal accountability. That if I outsource my work to a third party, both of them take the ownership and both of them have the accountability to comply with the act. Now, what happens is, in those cases, there's a lot of blame game which happens when there is an incident or when there is a breach. To ensure that that is not happening in India is where the obligation of data processor was removed. They wanted one entity to be accountable for the data which is collecting and processing, and therefore the processor has no obligation under the act. A processor's obligations come from the contract that they sign with the data fiduciary. So if you are a data fiduciary and onboarding some of the data processors, what goes in a contract becomes very critical when it comes to DPDPA. So all your contracts will have to be redesigned and redrafted to ensure that your processor, which are processing your data, so a payroll service provider, for example, what controls and clauses you are putting in your contract to safeguard yourself from DPDPA. I would cover in the subsequent slides why a back-to-back agreement will not suffice. Because that's what a lot of organizations have been saying, we'll do a back-to-back agreement with the processor, the monkey is off my back. But why that will not be sufficient, we'll cover in the subsequent slide. And the most important entity of the act is the data principle. Every other act globally, the term which is used is called data subject. In India, it is called data principle. The main difference is the ministry believed when you use the term data subject, a subject is not somebody who is an owner. A data principle is the term because it is the individual whose data is being collected and processed. So the owner is the individual and not the company. Therefore the word data principle and not data subject. When you use a data subject, it gives a control to the company. Here the government or the ministry wanted control in the hands of the individual. That's why the term called data principle, and that is one of the objectives of the act, to give control and power to the individuals on how and what of their data is getting used and by whom. That is the whole objective of using the word data principle. The sixth party that we have under the act is called consent manager. A consent manager is a entity which will sit between data fiduciary and the data principal. It is an optional service which can be onboarded by companies. This was again, it does not exist in any of the other laws globally. The objective of a consent manager is, there are a lot of companies who have smaller personal data, but they do not have the technical know-how and the skill set and the technical capabilities and the kind of money that is required to implement a whole consent framework and maintain it on their own. So they can outsource it to a third party called consent manager, who will be managing consent on their behalf. So large companies can always onboard a platform, but for smaller companies which are lesser personal data, lesser in terms of, not high in terms of revenue. So this was keeping in mind the mid sector companies, the entire MSME segment. Consent manager was created those companies in mind, wherein they can outsource some of the activities, the major part of the privacy management for them, and then the entity will be responsible for managing consent on their behalf. A consent manager will also be acting as a data fiduciary. They will have to get themselves empaneled with the Data Protection Board of India and ensure that all the requirements of a data fiduciary, they comply with those. So that is the consent manager. While you would see that we've already seen a lot of companies who want to be consent managers. So there are empanelments which are going on as we speak and would happen. This is another, so in terms of the banking concept, if I were to say, we have a concept of account aggregators. So there is sehmati.org, which is a account aggregator somewhere. Is a similar concept which would be utilized for consent across organizations. Essentially to streamline the consent which is not able, which the company is not able to manage. Okay. So we've covered the applicability, we've covered the key parties that we have in the Act. Now this is a little busy slide, but it covers the entire DPDPA on one slide. So some of the areas we've covered from the, if I start from the left hand side, we've covered what is DPDP, who is impacted or who it is applicable to. We've covered personal data, we've covered the date of enforcement, which is 13th May 27. So about 13 months left now. Before I go further, we've also covered what is a consent manager. For a company to be able to collect and process personal data, it should have the legal authority. A company cannot simply collect and process personal data. Under the Act, there are two lawful bases of processing. A lawful basis is which allows an organization to legally collect and process personal data. Under the Act, there are two: legitimate use and consent. The reason why across the globe, if I look at, so for example, GDPR has 6 lawful bases of processing. In India, it is only 2: legitimate use and consent. And we'll first talk about legitimate use, then shift to consent. A legitimate use is specific for those areas where I do not need a consent, or taking a consent is not practically possible. There are scenarios. First is individual comes and voluntarily gives consent that I want this data, this information, so please take my personal details, and I do not need to obtain consent. The most important legitimate use that we have is an employee and employer relationship, because there's an imbalance of power between an employee and employer. Therefore, a consent is not possible. Even if we were to make consent mandatory over there, it would not be possible to implement it because the certain rights that the consent gives, because an individual can withdraw consent, and the moment an individual withdraws consent, the organization cannot process. If an employee were to withdraw consent, how will I process his information? How will I credit salary? How will my work get done? Therefore, consent is not applicable in case of employee-employer relationship, and therefore the legitimate use comes into picture. Having said that, it is the responsibility of the organization to ensure what falls under employee and employer relationship. I need a KYC detail of an individual, I need the address details, I need the bank account details, I need the identification details for an employee to be able to do my income tax related aspects, to be able to get his identification, medical insurance, and so on and so forth. So for these, I don't need consent. But there are a lot of activities which a company does, such as which are voluntary. You do CSR activities, you do blood donation drives, off-sites. Wherever we have certain things which are voluntarily and does not clearly fall under the purview of employee-employer relationship, we would have to rely on consent. But about 90% of the activities for an employee and employer, we would not be needing consent. That is one of the bigger relief for an organization. The other piece where a legitimate use becomes more important and pertinent for a private organization is how do you handle your vendors' data? Because when you outsource it to a third party, there are a lot of cases wherein we create their IDs in our systems. How do you handle that particular data? So while the act does not specifically consider contract as a lawful basis, but section 7b in the rules talks about compliance to laws and obligations under the law. Therefore, organizations can utilize that and process the personal data of vendors under the legitimate use, and again not on consent. In my personal view, organizations wherever possible should try and utilize legitimate use and not consent. Consent wherever it is mandatorily needed should be used. It is one of the most easiest way to obtain consent. You tell the user, I will not let you use my services, the user will give you consent. But the problem is it can be withdrawn, and the moment it is withdrawn, maintaining the entire life cycle becomes difficult. So it is most easy to obtain but most difficult to maintain. Therefore, rely as much as possible on legitimate use. The consent, Patricia ji also mentioned, has to be freely given, informed, unambiguous, and should have an affirmative action. These are the 5 criteria that any consent that we take from 13th May 27 should meet. The reason specifically I am saying from 13th May, because the act becomes effective from 13th May. Does that mean I can collect data today without a consent? The answer is yes. Or a consent which is not aligned with DPDPA? The answer is yes. But on 14th May 27, I need to be ready with the obligations of data fiduciary, wherein I would need to send a notice, and any new data that I collect has to comply with the consent requirements. Now, we to a large extent cover the left side of the slide. Now moving on to the right part, a data fiduciary has 4 obligations minimum. I'll keep it simple. There are 4 mandatory obligations. Rest all are mandatory prerequisites that an organization needs to do. Notice, consent, storage period limitation, reasonable security safeguards. These are the 4 mandatory obligations. A breach and a contract fall under the reasonable security safeguards. Now, what is notice? A notice is given to a data principal at the time of data collection or at any points of data collection. A notice and consent go hand in hand. When I am obtaining a consent, I need to give a notice to the individual. So a notice, what would a notice include? A notice would essentially include what data would be collecting, why we would be collecting, for how long we would retain that information, for if an individual is not happy or wants to exercise certain rights, how can they exercise certain rights, how can they raise grievances. So all that will form a part of the notice. So when you go to any websites and you scroll down, you will have a privacy policy. In the data privacy terms, we call it as a privacy notice as well, because you have 2 policies, one that you display externally or a privacy notice, and the one for how you would run privacy in the organizations. So this is a privacy notice available at the touch point. When you click on the privacy policy, it will say what is the objective of the organization, why collect data, and so on and so forth. Under the Act, a notice has 2 aspects. A, it is retrospective in nature, which means all the data that I collect till 13th May, on or before 13th May, I will have to send a notice, a shorter form of notice to all my individual data principals, telling them I have their data, what all data I have about them, and what can they do, or what are the rights they have, or any grievance they want to raise. So please be prepared as individuals on around 13th May 27 about notifications, email, messages that we'll get from companies on how we can exercise our rights or where all we have our data with respect to companies. So that will give us as an individual a curtain raiser into where all we have our data. That is one. Second, a notice has to be available in 22 languages of the Constitution. It has to be available. I can choose English or Hindi, whatever I want to be as my primary language. But if a data principal comes and says, I do not understand English, please change it to Marathi, please change it to Urdu, the organization will have to and give that notice in that local language. There are 22 languages under the 19th section of the Constitution. So those 22 languages would have to be available on the website, mobile, wherever we give the notice to. A notice is wherever we give a notice, a consent typically goes alongside. Like I said, consent has 5 key parameters. What essentially the difference between a notice and consent is? Notice is telling me at a generic level what would the company utilize the data for. A consent is to which all I consent for. They may utilize data, collect my data for marketing, so in marketing, analytics, sales, so and so. But when they are collecting my data, there is a term called purpose limitation. The organization has to define the purpose for which they will be collecting my data. So if I want to go and create a user ID on a particular website or a application, there are terms and conditions which I have to agree. At the same time, there would be, we will see a couple of more tick boxes now. Agree to the terms and conditions, agree to receive promotions and notifications, agree to have data shared with the different entities or third parties. So these are 3-4 additional check boxes that we will start seeing from 14th May, which would enable the organization to segregate who all have given consent for marketing, who all have not given consent for marketing. The consent, like I said, can be withdrawn. The catch here is the process of withdrawing a consent should be as simple as giving consent. So we've seen places wherein if an individual wants to withdraw consent, he has to go to 5 different pages to be able to reach a place where I can say withdraw. If an organization does that, that is non-compliant under the Act. The process of withdrawing consent should be as simple as obtaining consent. So one of the other questions that we often get is, does consent have a life? Or can an organization use my data if I've given them consent once? A consent is for perpetual unless there is a change in purpose. So today you collect my data for ABC purposes. Tomorrow the organization diversifies and wants to use my data for B purpose. They cannot do that. The consent is to be utilized for that purpose, and the moment that purpose changes, consent automatically goes off. So tying consent to a purpose is very important and would be one of the key aspects why consent managers would be required to companies which can't maintain it in-house. In specific on consent, there are 2 more aspects. One is verifiable parental consent for children data. While a lot of organizations process today process children data. Going forward, a verifiable parental consent would be required for processing children data. Children is anybody under the age of 18 years. A verifiable consent would also be required for processing data of person with disability. How will you verify? The government has mentioned that you can use functionalities like DigiLocker to verify whether a individual is the parent for a particular child or not, and therefore the verifiable parental consent. The reason it is important is when it comes to educational institutes for schools which process tons of children data, there are certain exemptions also, because when the act came in 2013, it was purely blank that you cannot use children data without verifiable parental consent. When the rules came in, there was certain clarity on, so for example, location tracking. A school can do location tracking provided it is for the security and safety of the child, while any other organization cannot do that. So there are certain exemptions also when it comes to children data, but overall it is important to obtain verifiable parental consent for providing and taking children data processing. So we've covered two requirements or two mandatory obligations that we now consent and notice. The third is storage period limitation, or in a legal term it is called data retention. For how long do you retain data? Ideally, the data can be retained for the purpose for which the purpose is not met. But who defines for how long will the purpose be retained? So that's where a data retention is clubbed along with the other statutory and legal obligations. I'll take an example. When it comes to employees, while a consent or a notice may not be applicable, but storage period limitation, reasonable safeguards will be applicable to every organization. You roll out a job application. The application is available to everybody on the web. People come and apply on that job on your website. The individual is a potential candidate right now. Because he is a potential candidate, I will take consent and give him or her the notice that what all personal data will be collected, why it will be collected. Till the reason we are giving notice is because he or she has not become an employee yet. When they become an employee, it is legitimate use. Now, after the individual is not selected, after 2 months, the individual comes and says, I have a right under DPDPA for deletion, please delete my data. Now, an organization would come and say that, okay, I will delete, but I have a policy that I cannot again interview an individual till they've completed 6 months. So that's my business policy, business decision. So I cannot delete your data for 6 months. I will delete your data once my business policy expires. So there is a reasonable timeline defined. Now, if we switch this scenario to an employee relationship, you hire an individual, he works with you for 1 year, and after 1 year, the individual leaves. In the second year, the individual comes and says, I have a right under DPDP, please delete my data. Now, you have, as an organization, you have certain obligations. So you have you have income tax obligations, you have gratuity obligations, you have PF, then you have the law enforcement who can come and knock your door any point of time. What do you do in that case? So that's where data retention comes into picture. You define for how long you would need what data. Because when an individual becomes an employee, there is certain data that you, let's say, need for income tax, you need for PF. But that is only, let's say, 25% of the data that you collect about an individual when he or she becomes an employee. There is another data set entire. There will be offsites where the data is collected. There is voluntarily the individual gives data. There is attendance record. There is performance feedback. There are multiple other things about the data about an employee which is collected. Now, the regulation only says you need to have data for minimum 8 years, and therefore the financial data, which comprises about 25% of the data that you've collected, can be retained. The other will have to be deleted based on the request of the employer. Therefore, for you to be able to take this decision, what data do I need to retain for 8 years? What data can I delete after 1 year or 2 years? You need to know first, where is my data? Where in my organization, where all is my data? Is it there? It is there in SAP, it is there in a shared folder, Oracle, ERP, or in CRM. There is data in my dealer management system, there is data in CCTV, access control. There are multiple, so many places where the data of an employee is. We will have to draft out a journey or a data flow diagram where all the data is, who all have access to it, and this needs to be done for each process. And when so the term that we use for it is called record of processing activities, ROPA. It is not a mandatory requirement, but it becomes a mandatory prerequisite, because in the absence of this, you cannot give a notice, because in your notice you will have to tell what all data I will be collecting and processing, for how long will I be retaining. So I need to know where is my data, what all data do I have. I cannot do data retention in the absence of this, because I don't know where all my data is. How will I delete it, right? So therefore, having an inventory of data and the data flow of the data from the time it enters my systems to the time it is deleted, the entire lineage would have to be created. It is when in the journey of the implementation exercise for an activity, this is one of the most volume intensive activity. While there are tools which are available in the market, but typically this activity takes the most amount of time. Knowing what data to store, knowing what data to delete. For startups, they've given specific timelines that if an ID is not utilized for 3 years, that needs to be deleted. For an organization to delete, they need to send a notification 48 hours before deletion to give the individual a chance to reactivate the system or the ID, and therefore specific deletion requirements on those. If I were to extend the same requirement to a customer, the same retention policy will be applicable. Let's say I go on Apollo 24/7, I order a medicine. They can store my data for a particular period till the time they have to maintain their balance sheet and financial years. After after that, I can reach out to them to exercise my rights, and they will have to delete my data. But if I were to further extend it to, let's say, a electronics manufacturing company, a Samsung or an LG, I buy a washing machine or a fridge from them. The product has a particular life, so they give me a warranty for 1 year, 2 year, 3 years, and then there is a service period. When a customer comes to a Samsung or an LG and asks for data deletion, the organization can then pick up the warranty clause saying that we have to service, and if we delete your data, we would no longer be in a position to provide the services that is needed. So therefore, data cannot be deleted, because when you can't service, it impacts the reputation, it impacts your contractual obligations, and so on and so forth. Therefore, a data retention requirement is managed through your statutory obligations, regulatory obligations that you have to comply with, business policies, and your contractual requirements. All of those combined together would determine for how long an organization can store data, and for after how much time should they be deleting data. So this is one of the till now there are organizations who managed to crack it, but it is a very difficult and cumbersome activity, because on paper you will be able to define it. that in HR I have 50 data elements. I will retain 25 for 5 years, 25 for 8 years. After 8 years, I will delete. But how do you map or tag those 25, which is to be deleted after 5 years and the other to be after 8 years? So tagging and classification is a process as well as technical challenge. While there are systems available, the effectiveness of those is still to be evaluated at 100%. So the organizations are still struggling to meet the data retention requirement when it comes to different acts, and they are trying as much as possible wherever. In the startups are to an extent able to do that because the data enters in one database, they've been digitally native, so they've built in this requirement, so you can request for your account deletion, but there also the deletion is limited of what all they will go ahead and delete. This is one requirement which will be keeping organizations on their toes for a long time and most difficult to implement. The fourth requirement that we have is reasonable security safeguards. Very simple, very open-ended. What government has done is, in addition to these, they've given certain minimum controls. So they've mentioned access control, encryption, business continuity, logging and monitoring. So these are some of the controls that they've mentioned in the rules, because in the act it only talks about reasonable security safeguards. Therefore, in the rules they clarified it a bit. Now, most of the organizations across India are not at zero. Every organization has implemented some controls, whether it is about implementing a data loss prevention solution, access control, encryption. Every organization has implemented one or two other control. You need to be able to assess it, whether those controls are meeting the requirements of DPDPA or there is a need to enhance. One such specific ask that they have under this is breach notification. Whenever there is a breach, the organization needs to inform the individual as well as the board immediately upon identification. Now, when we were consultations are happening, we gave a feedback on this, that there should be a threshold to attach to it, because the definition of breach is very broad. HR employee by mistake sends a salary file to a legal is a breach. Employee leaving a personal data file on printer is a breach. External attack happening on a customer database and data getting exposed is a breach. So the definition of breach is very broad, and therefore a threshold concept was suggested for this, but it was not taken into consideration. So as we speak, any breach that any personal data breach needs to be reported to the individual and to the data protection board immediately, and with a detailed report within 72 hours. Today, organizations already have this requirement. Certain mandates this at 6 hours. RBI 24, SEBI 72. So there are different regulators, different requirements. So an organization, depending on the sector that they work in, will have to identify the most strict requirement and follow that, and accordingly ensure that the relevant controls are implemented. Now, across laws, one of the key aspects that they've talked about is upon identification. Globally, as per the different research report that we have, the mean time to detect or identify an incident that an organization takes is about 240 days. From the time of external breach happens to the time it is detected and reported, it is 240 days. The point here is, the organizations have always been saying we were not able to detect, and therefore the incident was not identified. all of these obligations start when the incident is identified. So even if I am detecting that incident after 240 days, I will go and report it on the 241st day to the board as well as to the individual. I have complied with the requirement, right? But that's where the catch is. The MITI and the Act says under reasonable security safeguard, they have a provision of logging and monitoring. The whole point of that logging and monitoring mandating is it helps you to detect data breaches. And therefore, if an organization is not able to detect a particular breach, which means they've not implemented the reasonable security safeguards appropriately, and therefore the highest penalty. So there are different penalties that we have, I'll cover in the subsequent screen. The highest are 250 crores and 200 crores. The first one is on not implementing reasonable security safeguards. 200 is on breach, not able to do breach reporting. So this one clause takes care of about 450 crores of penalties. That is why it is easier or most open-ended, but gives organizations a flexibility on what is applicable to them and how should they implement the controls. The next is contracts with data processor. This is not a mandatory obligation per se, but for an organization to be able to outsource something, they would need to have a contract. Now, when we started, we were talking to lawyers. Lawyers said, okay, no problem, we'll do a back-to-back contract. Kya problem? Everybody will say, I don't get penalized, so I will put it on my processor. Very good, everybody was happy. But, and recently I read about a case. So there is a company called Comcast. It's one of the largest media service providers globally. There was a breach, and it is public information. There was a breach which happened at one of their processors. Both of them are equally accountable under the CCPA Act. The regulator very happily fined $1.5 million to the processor. Everything is hunky-dory till now. The processor went and declared bankruptcy. Now that entire $1.5 million is being paid by Comcast. This is for the lawyers who say back-to-back agreements. There the processor declared bankruptcy in $1.5 million. In India, they'll declare it in 1 crore. The kind of service providers and data processors we have, if there is a penalty on them to the extent of 1 crore, forget 250, they'll declare bankruptcy in that. So a back-to-back contract simply will not suffice as a solution to ensuring the accountability is managed with your third party. The organization will have to do much more. 2 steps or 2 to 3 steps they will have to undertake. First is be careful in choosing the service provider that you are going ahead with. A cheaper one does not mean he is the most safest one. Second, assess your third parties before you onboard them. The reason I am saying assess is because not every third party will be equal. A cafeteria service provider may not need to have the same level of clause vis-a-vis a payroll service provider or a IT service provider. So the clauses that go in your contract will differ by the type of service provider, and therefore the kind of assessment that needs to be done will also have to be as per the category of the service provider that we are taking in. When we go into a little more depth, the type of data shared, the categories of data shared also makes an important aspect on what type of third party to onboard. So this is contract with data processors is like a unsaid requirement which will be added to the data fiduciary on which third party to onboard in their ecosystem. It's like any the Hindi term that we do is when you want to buy a thing, ठोक बजा के लेते हो. Same would be the case here. Whichever third party you onboard, please assess before you onboard them. A mere contract will not suffice. You may end up in a situation wherein a breach happens at your data processor. The penalty would be on the fiduciary, because under the act there is no obligation. The only obligation that a processor has is through the contract. So if I don't write in my contract the obligation, the processor has no obligation. Therefore it is important. When it comes to, so these are the only 4 requirements that are applicable to a data fiduciary. If an organization is classified as a significant data fiduciary, there are 4 additional requirements. First is appointment of a DPO, a data protection officer who is responsible for implementing DPDPA in the organization, to be based out of India. Not a very complicated one, simpler one. Anybody can be a DPO as long as they are capable and skilled enough. A legal team can be a DPO, a security team member can be a DPO, so it is not very complicated and flexible enough. What is the important requirement here is conducting regular DPIAs, data protection impact assessment. We've all heard of risk assessments on how do you identify and assess risk across your different processes within the organization, whether it is enterprise risk, security risk, and so on and so forth. A DPIA is doing a risk assessment for your data. What are the risks, in what process, what control should I implement? That is DPIA. It is good to have for a data fiduciary, but for a significant data fiduciary, it is mandatory for all your processes. How it helps, and whenever we do any engagement or a project, one time we do it for sure at every client, because the kind of depth or that a DPIA gives, or an understanding of the ecosystem that a DPIA gives, the other controls do not essentially give. It tells me which application, which control should I implement, where should I implement an encryption, where should I implement a DLP solution, within DLP what control should I put. So the extent of technical assessment that gets done on a DPIA, you don't typically see when you do a regular assessment. That's why it is, from my perspective, I do it once at every client. Globally the laws mandate to be done it every 3 years. India, it needs to be done every year. The other requirement, like the Indian ecosystem is very in love with the audits. There is a requirement for an independent data audit to be done every year. So similar to we have certain empaneled auditors, we will have DPDP auditors who would be onboarded, utilizing which the company will have to get an audit done every year, the data privacy audit to be done. And then the last is embedding this into the internal audit lifecycle for an organization. One is an internal audit, one is an external audit. Both needs to be done annually. So from a additional obligation, it's merely about getting more assurance from a significant data fiduciary that they've implemented the requirements in a more specific and in-depth manner. So that is those are the additional obligations for a significant data fiduciary. Now we've talked about right now the obligations of data fiduciary. There are 2 more words that we had: rights and duties of a data principal. So a data principal, which is the individual like us, has certain rights under the act, which allows or gives the control on how our data is used. One of the first touch point or the control we have is consent. After consent, as an individual, I have a right of access, correction, completion, updation, and erasure. Which means I can ask an organization to tell me what all data do they have about me across the different ecosystem. I was talking to one of the DPO for a large airline company, and she said what keeps her awake is not a right to erasure. The right to access it was what keeps her awake. Because where all the data is, which all files, which all Outlook emails, it is next to impossible to identify and inform. So but an individual has this right, if not 100%, in my view, companies would be able to give 90% of the data that they have about the individual and tell them what all data is collected and processed about them. Correction is simple. What all data, if there is an incorrect data that the company has, I should be able to get that corrected and updated. Erasure is one of the difficult, I would say, the rights that an individual has. This gets clubbed with data retention requirement that I discussed in detail. I have the right to get my data deleted as an individual, but that does not mean that on the whims and fancies of the data principle, the company will delete data. The company has the right to retain data depending on their regulatory obligations. But where there are no obligations, so which is typically in case of marketing agencies or any customer related agencies where they don't have a regulatory obligation, they will have to delete my data. So if not 100%, 60% of the cases you would be able to get your data deleted. There are two additional rights that we have under the Act: right to grievance and right to nominate. A right to nominate, and these two are the additional rights when I say specifically because they do not exist in any of the other laws globally. These are specifically for India. A grievance redressal essentially is if I am as an individual not happy with the response that I get as part of my normal data principal request, I can raise a grievance. So it is important for the organization to have a grievance officer. And the details of that grievance officer should be mentioned in the data privacy notice that is given. And the timeline for an organization to resolve a grievance is 90 days. I as an individual first raise a data principal request, the company does not respond. I raise a grievance, they have about 90 days to resolve, the company does not respond. I can then go ahead and complain to the data protection board, that will then be bound to investigate. So even if an individual raises a complaint to the board, the data protection board would first tell them to go and raise a grievance. So in my view, more than the rights, the companies would be taking grievance redressal more seriously, which is what happens today also in the consumer scenario. When you have a consumer grievance redressal mechanism, the same concept has been extended here. The right to nominate specifically comes in case of death or disability of the data principal. If the individual becomes disabled, they can nominate someone who can manage consent or any other requirements of the Act on their behalf. This is similar to the nomination facility that we have in banks or other places. I have a right to nominate someone who would manage consent on my behalf. The other reason why nomination becomes is because this allows them to onboard a consent manager as well whenever required. So that is the reason specifically the right to nomination has been added. Having said that, that does not give a free right to the data principal. There are certain duties as well. So which means and in case those duties are not fulfilled, there is a penalty of up to 10,000 rupees for the individual also. So the whole reason of adding this penalty was, so when GDPR came into effect in 2018, companies saw a lot of class action suits on them, typically essentially to get settlements, to get those. To avoid those is what the duties of the data principal has been defined, and a penalty on the individual. The certain duties of the individual that we have is, I will not impersonate anybody. I will not share wrong data. I will not falsely raise data principal requests or grievances. So these are certain duties which a data principal needs to follow. in the absence of which, so if an individual constantly goes and raises a concern, the company also can go and complain to the board against the individual. And there is a provision to fine the individual also, in addition to the penalties that the companies may be penalized for. So this in nutshell what the act is all about. So I'll take a pause and see if there are any questions before I go to further slides. Yes, sir.
You talked about data fiduciary, which is basically a company. Significant data fiduciary. Significant data fiduciary means a large company or a, I mean, how do you define that?
So-
How do you define that?
A significant data fiduciary, like I said in the previous slide, it is a subset of data fiduciary only. The difference is large volume of data, high risk. So these will be the set of companies which will be identified and told by the government. As
Okay.
of now, they have not given the
Okay,
names.
so there's no benchmark as of now.
There is no volume whether a company having 2 crores customers will be a significant data fiduciary.
Okay.
So there is no number, but
Oh.
they've given the parameters only.
One more simple small question. Say a manufacturing company, B2B, not dealing much with the data principles, and have their own employees which can go through your
Legitimate use.
Yeah, legitimate use. In that case, they do not need to go in for this compliance.
So every organization needs to go with this compliance. What they will not have to do is only the consent part. Reasonable
Security and all is okay. I'm
Sec-
talking about
Ha, so
security part, breach part. Those are okay. I'm talking about the consent.
only consent is in case of an employee is not
But what
applicable.
about the notices and all? They don't need to do then.
Under so consent notice.
Yes.
The reason you will have to give a notice is in case of employee-employer relationship, there are areas where you would end up obtaining a consent. CSR, voluntary activities. So consent, although not mandatory, what would become inevitable in a lot of cases.
There could be individual agreements between employees and employer and all that. So what I'm talking about, the consent, say your DPIA, your ROPA, your data discovery.
Those anyway would have to be done, because in the absence of ROPA, you will not be able to do a data retention. Or DPIA is only mandatory for a significant data
But data
fiduciary.
retention, suppose if you are not dealing with the normal day-to-day data principles,
Yeah.
you're in a B2B situation.
Right.
There only the internal is the
Right.
issue. That is the internal employees.
Right.
So with that internal employees, you can have agreements.
You can have agreement, but the employee can come back after they've resigned and come back and ask for deletion, no?
Yeah, that of course, yes, yes. Thank you. Thank you, thank
I
you.
thought it was 6:30. I've covered majority of it.
So, what I requested Mr. Kalra is just to finish whatever couple of things he has to show further, and then we start the interactive session. Thank you.
So we've covered what the act is. Now the specific on the timelines. So the act came on 11th August 2023. The rules came in 13 November 25. The implementation of rules is in 3 stages. The first is setup of data protection board, which is a government obligation. They've identified people and they've set up a data protection board, their website and everything. They are in the process of creating. The second phase, which happens on 13th November 26, is registration for consent manager begins, which means any entity which wants to be a consent manager, they can get themselves empaneled and get registered with the board. 13th May is 27 is the date when the act becomes enforceable. So it is 18 months ideally from 13th November, but from today it is about 12 months which an organization gets. And trust me, you would need good amount of time to implement. Okay, then we've talked about penalties. So this is a breakup of the penalties that we have. So if you see, the highest penalty of 250 crores comes in reasonable security safeguards. 200 crore is for breach happening and I am not able to provide notice to the individual and to the board. The other 200 crores comes in when a breach happens with respect to children data obligations. If I am processing children data without verifiable parental consent, that's where the another highest penalty comes to be 200 crores. The if I am categorized as a significant data fiduciary and I am not doing regular audits, not doing DPIA, there is a possibility of up to 150 crores. Then if as an individual or as an organization I am missing out on any of the other provision, data retention, not obtaining notice, consent, there could be a penalty of up to 50 crores. And if an individual is in breach of the observance of his duty, he can be penalized up to 10,000. So if you see, the highest penalties are on three: security safeguards, breach, and children data. The message, giving the clear message that data protection is important. How I collect and use my data and safeguard that data becomes important. So security of the data, at the same time ability to identify a breach is important, and that's why, and if you were to talk to a lawyer, the act is data protection. In the entire act, nowhere it talks about privacy. The privacy as a word does not exist under the act. It has talked about consent and notices, but if you do a control F, we will not find the word privacy. It is for protecting and managing how the data is used. So that's how the penalties can be accumulated, and the highest penalties can be upwards of 850 crores to a company. So I've already covered these, so I'll skip these. I'll specifically cover this part. This part on what is a roadmap to a compliance for an organization that they can take. So, like I said, across the board, every organization will have one or the other control. Any organization that you go to, when you go and check on their website, they will have a privacy policy. So typically what we've seen is every organization whenever they got their website developed, the website developer has invariably added a privacy policy that may or may not be followed internally in the organization. But there is a privacy policy in most of the cases that it exists. And similarly, how the data of employees, customers is used and collected in the organization is also somewhere controlled. It does not flow randomly across the organization. Therefore, the first two stages, identifying what is applicable and doing a current state assessment on where do you stand today. What control do you have, what control you don't have. And how that helps is, that helps you to identify a roadmap on what do you need to work upon. There are 12 months which are left, and therefore you need to prioritize what do you need to work upon. And that's where the first two stages essentially tell us, knowing what to work upon and what are my gaps. This is generally followed with data discovery and classification. So the ROPA activity, recorder processing activity, which I was talking about, that's when this is what the actually starts with, knowing what data you have and which all people that have access to. When we've done this activity with the clients as part of the engagement that we've done, we've come across cases wherein there are servers which are left and the organizations have no idea that we have servers with so much personal data. What happens generally is, whenever the team is developing they create a development server, they create a copy of the production data, and then when the application goes live, the dev server which was created typically in a lot of cases is not decommissioned. It is just disconnected from the network and is lying somewhere. So that's where the concept of shadow IT comes into picture. There is a lot more shadow IT which is available in the organization than we actually assume and then we know of. So knowing what data is where and who all have access to it becomes important. So data discovery is one of the initial aspects of it. Along with discovery, what is important is classification. Not every data comes under the purview of the act. So therefore we need to know and classify what comes under the act and where is that data. So classifying that data for us to be able to implement those relevant controls across the system. And design and documentation becomes important because for any organization to implement a complex program like this, you need to define the framework and the guardrails. How will privacy be run in the organization? What policies? Who would do what? How will a process for a data principal right happen? So there is a lot of design of the and the documentation which needs to happen, essentially setting up the framework which will be rolled out in the organization. As we define and set up that framework, is the next is how do you roll it out? Identifying every website, mobile application, every touch point, internal as well as external, where you need to put notice, consent, rolling out third party risk management program, technical security controls, implementing those. The entire implementation takes about 6 months. And there would be certain areas where you will need to have capital expenditure. Capital expense will come into picture if the tools do not exist in an organization. So you'll have to budget for those, buy those, and then roll out those in the organization. So there is a certain time which is attached to that. Therefore, implementation and rollout is important and is time consuming. Third party risk management. You will have long standing contracts running. It is not practically possible for every contract to be updated whenever we want. A lot of legal teams would wait for the contract to come for a renewal and then update. So ensuring that new contracts follow a certain data processing agreement. There is a data processing clause in every agreement that gets signed is important, and implementing a due diligence for third parties is also important. And secondly, if you are categorized as a significant data fiduciary, doing DPIAs, impact assessments across the journey of the life cycle is another next step. And one of the key aspects is setting up a privacy office. Up till now, till DPIA, you can hire a consultant who will help you do this. But after the consultant leaves, somebody needs to run it in the organization. That's where a privacy office becomes important. Whether it is a privacy officer, whether it is a DPO, who will work in the privacy office team, who will act from business function, who will be responsible to help him implement, and so on and so forth. And lastly, the audit and review. And if an organization wants to further enhance their maturity, that's where the automation technologies comes into picture. There are a lot of tools and technologies which are available which organizations can use to further enhance. So this is a same slide but a different version. If you see, from November till April has lapsed. Last 3 months we've kept for audit and independent audit. If you were to spend money on this kind of program, your board and management will come and ask towards the end, can you get an audit done and give me a report? So last 2-3 months are essentially reserved for that. So that leaves us about 10 months for an organization to define and implement a privacy program, which in my view is much lesser compared to what the organizations got for the others laws that they implemented. So 10 months doing everything, even if you are a small organization, it is a lot of effort. So I think that was the slide. There are slides on what small businesses and others need to do, but we can skip that. So I think that was my last slide. So thank you, and after we can take questions.
Thank you, Mr. Kalra. I think this was a wonderful presentation on a very important subject of the day, otherwise which would have remained an enigma. With this, ladies and gentlemen, we open up the house for interactive sessions. We will have, please ask questions and keep them short and not make statements, and let the experts speak. So with that, over to you. Yes, first.
Thank you, Mr. Kalra. Incidentally, let me also mention that being an ex-EY person in HR, it's nice to see you there.
Thank
In
you.
fact, I also had the good opportunity to recruit even Harish.
Oh, wow, very good.
Okay, so my very quick questions, what could be the liability of an employer as a data fiduciary or significant data fiduciary, whatever you say, under DPDP Act for the personal data of their ex-employees before a third party who does the BGC, background check, before recruitment of a prospective candidate?
So, you're saying the liability or an obligation?
Liability. As a fiduciary, or say,
So if so, I'll rephrase, summarize the question. I am a fiduciary. I have an ex-employee whose data I have, and then somebody reaches out to me for their background check. That's the scenario.
yeah, exactly.
Uh, okay. In this specific case, you have to understand how would somebody reach out to me. Whenever these cases happen going forward, I would need to check with the individual or the entity reaching, show me how you have the consent
Okay.
of the previous employee that you have. You would need to check that consent and maintain those in your records, so as to tomorrow if the individual comes and says, why did you share my data, you need to have a valid proof of that the entity requesting for a background check had obtained consent of the individual before you initiating or sharing the background check. So that is what will have to happen. And if the entity does not do that, if let's say a data fiduciary does not do that, the individual will have every right to raise a complaint, and then the entire investigation follows.
That means there could be significant changes in the exit interview form also.
Yes.
Has to be. Okay. So my last question would be that whether business houses with LLP status, will they get any kind of a waiver from this act?
No, every company is the same.
Thank you.
Yes.
I have a small question. Like we were saying, when the data is physical and we digitalize, then DPDP starts. So if a person, again, employee leaves the organization and we just keep the data in physical form, whether I am offsetting the DPDP Act for me.